Now Shantaram Naik. Shantaram
Sir,
Naik.
sir, I welcome,
Yeah.
I welcome the fundamentals of this
No.
historical
Ask
bill.
them to allot 3 hours. 3 hours. Now silence. Yeah. Silence.
I said I welcome the
VP
fundamentals
Singh, but no.
of this historical bill.
VP Singh, but no. Mr. VP Singh. Please proceed. Now all of you, see order please. Order those who are in the passage, please go to your seat or go out. Those who are talking, please don't talk, including the ministers. Please don't talk. Listen to the member, honorable member speaking. Such a very important bill. Everybody to take it seriously, please.
I am repeating for the third time that I welcome the fundamentals of the bill. I consider this as one of the steps towards restoration of supremacy of parliament. The supremacy of parliament is being eroded by various judgments pronounced by the judiciary from time to time. And therefore, this is one step towards the restoration of supremacy of parliament. It is unfortunate, as early as yesterday.
Now please, those who are standing and talking, please take your seat. Now please.
It is unfortunate that as early as yesterday, the Chief of Justice of India has said that collegium system is the best one and that there is a conspiracy against judiciary, that a high judicial officer should pass her remarks when it is known that Parliament is enacting a constitutional amendment as also a normal legislation to establish the Judicial Commission. If you see the history of the constitutional provisions, it is Article 124(2) which laid down the procedure for the purpose of appointment of judges. And that article, may I read, that Article 124(2) says, every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation with such of the judges of Supreme Court and of High Courts in the state as President may deem necessary for the purpose and shall hold office until he attains the age of 65, provided that in the case of appointment of a judge other than Chief Justice, the Chief Justice of India shall always be consulted. So this was the article, fundamental article, which was incorporated in the Constitution of India, which was framed by late Dr. Baba Sahib Ambedkar and others. Who has played with this article? Was it a normal, ordinary legislation which was played with? If you go to Supreme Court and a High Court, if you play with any provision of law, that act is struck down.
This one, after this.
Deputy Chairman, sir,
Krishna, then Majid.
if somebody plays on ordinary legislation, that act is not accepted. And here, the Supreme Court of India was playing with an article of the Constitution of India, which is a sacred document for the country. And how they did it? They sidetracked this very precious article by passing a judgment, which is called as collegium judgment, and usurp the power of the government of India, of the executive, in their own hands by scrapping virtually a clear provision of law. Everywhere in the world, most of the countries, the executive has the authority to appoint judicial officers by following a proper procedure of consultation. In most of the countries, if you go to see, this procedure is followed. And nowhere judges appoint themselves as judges. And therefore, this step of the Supreme Court of India to throw away Article 124(2) in the dustbin and pass a judgment and grab the power of Parliament and of the government was an act which I can say a judicial theft. But on account of various circumstances which existed between this period of collegium judgment till today, that the government could not dare to confront the judiciary. Somehow, in the Lok Sabha, one party has got a considerable majority, and we are also cooperating. Therefore, this could see the light of the day. Nobody should understand us, we are opposed to Judicial Commission. On the contrary, myself and many of my colleagues have always said we have to control the actions of judiciary in various fields which are going on. Therefore, this is one of the best steps that you have taken, and we'll welcome it. Subsequently, why this collegium system has been criticized by various judicial luminaries, advocates and others. Collegium system is not perfect. It is a system which is rotten with nepotism. As everybody knows, that judges among themselves who have taken the power of Parliament and the Government of India, they recommend judicial officers, my brother, your sister, my brother-in-law. They try to adjust, and if there is no unanimity on any of the relatives to be appointed to the judicial post, then these vacancies remain. Some people are asking why vacancies are remaining. The major reasons for the vacancies remaining in various courts in the post of judicial officer is this: they are not able to settle who should be appointed. And therefore, this is one of the biggest hurdle in the appointment of judges in various courts. Secondly, I would like to make a fundamental point. Appointment of judges comes under category of
2 minutes more.
May,
2 minutes more.
I am initiator of the debate. No, question I have, let me tell you very frankly.
You have
I am initiative.
Okay.
See, please don't.
आप चलिए.
No, चलिए. I should not make such statement, please. With due respect. With due respect. Question is, what is this appointment of judiciary? It comes in the category of basic structure of the Constitution. Will any authority in the country dare to change basic structure of the Constitution? If the basic structure of the Constitution is changed, then that action will be struck down by the court. Supreme Court will throw away that action because it goes against fundamentals of basic structure of the Constitution. And there is no doubt that this appointment of judges is basic structure of the Constitution. As the chairman of Parliamentary Committee on Personal Law and Justice, Attorney General of India appeared before me and he made a statement that the appointment of higher judiciary is a part of basic structure of Constitution, as it was at the time of its enactment in 1950, has to be considered from the point of view of basic structure doctrine of the Constitution by interpreting the word consultation to mean concurrence. So there is no doubt that this article and this structure amounts to basic structure of the Constitution. And can you imagine the Supreme Court of India changing the basic structure of the Constitution? For whom? For usurping power to themselves. To get power of appointment of judges to themselves by passing a judgment, they change the basic structure of the Constitution, which is not pardonable. And as I said earlier, in no country, most of the country I am mentioning, that judges appoint themselves as judges. There is always a major role given to the judiciary, like in UK, South Africa, Russia, Canada, Sri Lanka, Japan, and many other countries. So they follow this procedure where executive takes priority. Now, what is this 1993 judgment? 1993 judgment, in short, is a coup against parliamentary powers. Why I am saying coup is because you are passing a judgment and taking away powers. You say there shall be a collegium consists of these judges, and no longer the government of India will have a major role in the appointment of judges. This is contrary to this. Therefore, I call it coup. Secondly, what are the roles which are being played at present by the judges? I was told by a responsible member of parliament that one Supreme Court judge used to send file recommending a particular person as judge, and thereafter used to phone the Prime Minister, don't appoint this man, he is so and so, so and so. So therefore, these things, please, don't interrupt me. Secondly, one of the judges who has taken oath on the Constitution of India, oath is sacred, one who has taken oath on the Constitution of India says publicly, if I was the dictator of India, I would have prescribed Gita in various schools. Gita, everybody wants. It's a very precious document, precious thing. But can he, who has taken oath under Constitution of India, say publicly in a meeting that if I was the dictator of India, and say so? Is this how the judges should behave?
Yes, just come, just go on.
No, I would, yes. Secondly,
I have come back.
incidentally I am mentioning, only auxiliary points I am mentioning, that we have heard that in Madhya Pradesh, a High Court judge, we have listened to his case, there was a 0 hour mention by luminary, by Tulsi ji, yesterday, that how a lady additional district judge had to leave the job because she was asked to perform a dance in a particular place, and other things. That inquiry is being ordered by the Supreme Court judge. 2 members have been appointed. So this is what is going on in certain place. Now, sir, another aspect is law declared by Supreme Court is a law which is applicable and binding on all courts. And this is the Article 141, which is being used by the judiciary not only to interpret. If they only interpret vague provisions, ambiguous provision, it is welcome, because that is their job. But in the guise of Article 141, what did they do? Today they have taken departments of Government of India. There are empowerment committees appointed by Supreme Court which are deciding matters which ought to have been decided by those respective departments of Government of India. You can imagine, I'm only citing the case of Environment Ministry, of which I know. I don't know how much power Javadekar will be having after this thing. What is meant by law declared? Is it means that you can just in the name of interpretation lay down the new law? There are ample judgments, law minister will be knowing, there are ample of judgments in which guidelines are laid down in various matters, guidelines, as if they are acts of parliament. And we have been following those guidelines as if they are acts of parliament, passed by parliament, they are following. And secondly, as it is said, the ignorance of law is no excuse. If ignorance of law is no excuse, then searching law in a judgment is like searching a pin in a haystack. If I want to know one proposition of law, I have to read 100 pages or 200 pages of a judgment to know what the proposition is. So therefore, judges themselves are not following or facilitating common men or even lawyers to understand the proposition of law. Another aspect is, if anything, if supposing this bill is violative of Constitution, then there are two methods, two criteria. One is that you have to go into the list, concurrent list, union list, state list. That will decide whether a law, government, parliament is competent or not. Second thing is violation of fundamental rights. Now this is very vague. Now if you read fundamental rights, you can stretch any fundamental rights to strike down anything. So these fundamentals are very important. Put interpret a fundamental right in such a manner as to strike down any normal legislation or normal act of parliament will be a superfluous thing. Secondly, after the Judicial Commission is constituted, today we are showing our supremacy by passing this legislation coupled with the ordinary legislation that we passed. We are showing the supremacy. In that supremacy, in that, while constituting the commission, you have also to be transparent. You should not emulate the Supreme Court. Let that action of yours be transparent. Be transparent. You know what I mean. It should be transparent, and proper eminent persons of integrity should be made as eminent. I thank you for one thing, that I made one recommendation in my report, and you have included that. That representation one of the eminent persons should be from SC, ST, women or minority and OBC. You have accepted that. I welcome that. So therefore, accordingly, I hope that you will implement this legislation and ordinary legislation in a right spirit for the overall interest of the Government of India and of Parliament, and take further steps from time to time to ensure to protect the interests of Parliament. Thank you very much.
Thank you very much.